of you have already started. Great minds think alike, right? With the recording. Okay. So, with all of that said, let's dive right in. So, I don't want to assume the level of knowledge here, even though all of you are industry experts. Um, so, if some of this is sort of old school, like we know that, Betsy, forgive me, because not everybody is on the same level of knowledge here. So, in the federal student loan programs, we essentially have two buckets of repayment plans. We have the repayment plans that are based on income and the repayment plans that aren't based on income. So the repayment plans that are not based on income are the 10-year standard plan, which is the plan that a borrower gets when they first go into repayment if they don't consolidate and they don't actively choose another plan. For many borrowers, this ends up being the cheapest plan over time, with the exception of that being if they have really high debt and fairly low income compared to that debt. But, as you guys know, in general, the faster you pay the loan off, the less you're going to pay in interest. And for many borrowers, the 10-year standard plan is the one that's going to achieve that goal. We also have graduated repayment. Graduated repayment is sort of self-explanatory. You start off as interest-only payments for the first 2 or 4 years, and then the payment gradually increases year by year, and you're still paying the loan off within 10 years. This plan's been around forever, as long as I can remember, and it's a good plan for, if you assume that a recent graduate, their income might be on the lower side, but hopefully their college education will pay off and their income will increase over time, as well as their ability to make larger payments. Extended repayment is sort of like consolidation without actually having to consolidate. You're making the same payment every month, but your term is 25 years instead of 10 years, but you still have your individual loans, whereas consolidation, you're paying off your individual loans and creating one great big fat new loan that has a term of between 12 and 30 years. So extended repayment, you have to owe at least $30,000 in federal loans to qualify for it. And again, the payment is going to be the same every month, but over a 25-year term. This can be a useful plan for Parent Plus borrowers who, as you'll see, aren't eligible at least initially for the income-driven plans. But it could also be useful for someone who has a strategy where they want to pay their loans off aggressively, but they want to target individual loans for the extra payments. So extended repayment can keep the minimum payment due low on the individual loans, but keep the loans individual so they can target the ones that they want. And then, of course, you can mush those two together and get graduated extended. So interest only the first couple of years, but the terms extended to 25. All federal Stafford and Plus loans, whether they be Parent Plus or Graduate Plus loans, are eligible for all these plans. It doesn't matter when the loans were taken out. It doesn't matter whether they were consolidated or not. As long as they're not in default, all federal Stafford and Plus loans are eligible for these plans. And then we have our income-driven plans, which is the core reason for this presentation. The income-driven plans, I can completely understand why borrowers get confused because let's face it, they're all exactly the same except where they're different. In fact, 2 of them have the exact same name, but have completely different terms. So it makes complete sense why borrowers get confused by these plans, especially lately with the SAVE litigation and which we are going to talk about at length, and the pauses on these plans and so on and so forth. But to go back to the ABCs of the IDR plans, what we have today that are viable plans are old IBR, new IBR, pay as you earn, and ICR. Now, old IBR is the only income-driven plan that is available to both FFEL loans as well as direct loans. All the other plans are only available to the direct loan program. It doesn't matter when you took out your first loan for old IBR. The only people that can't get on old IBR are Parent Plus borrowers, although if they go through what's called the double consolidation loophole, which I believe I cover in a little bit, they can actually access old IBR as well. New IBR is only for only for direct loans, Again, Parent Plus loans aren't eligible unless they've gone through the double consolidation loophole. And it's only for borrowers who have no loans made prior to July 1st, 2014. Now, one thing about old IBR and new IBR that's important to notice is that old IBR and new IBR are written into federal law. So with all the SAVE litigation nonsense going on, those plans are not at risk due to the SAVE litigation. And the forgiveness components around old and new IBR also aren't at risk due to the SAVE litigation. And again, I'm going to talk more about that in a little bit. Pay as you earn, as you'll see, I call that the fraternal twin of new IBR. The terms and conditions for new IBR and pay as you earn are exactly the same. Exactly. The payment calculation is the same. The potential forgiveness component is exactly the same. The only difference is who's eligible for it. And for pay as you earn, you're eligible as long as you have a direct loan and didn't take any loans out prior to October of 2007. And of course, once again, our Poor Parent Plus borrowers are excluded unless they've done the double consolidation loophole. Finally, we have the grandpappy of the income-driven plans, which is income contingent repayment. Now, income contingent repayment is also written into federal law. It was brought into play when they created the direct loan program back in 1994. This is the only plan that Parent Plus borrowers can access without going through the double consolidation loophole, although they do have to consolidate their loans to access ICR. So Parent Plus borrowers with a single consolidation can get ICR as well as the non-income driven plans. And again, ICR is only for direct loan borrowers. So, sorry, I'm very dry today. All right, so here are the things that all the plans have in common. They all base their payments on the borrower's income. In general, they're using adjusted gross income, although if the borrower chooses to submit pay stubs rather than their most recent tax return, they do use the gross income. They all require annual recertification, except when they don't, which we've seen a lot of since COVID. But the time frame for borrowers having to recertify their income on an annual basis is I assume once the SAVE litigation is over, and assuming we don't have any further injunctions, that borrowers should once again expect to have to recertify their income annually. Going back to the income, they all include spousal income if the borrower files their taxes jointly with their spouse. They exclude spousal income if they file their taxes separately. Now, if they live in a community property state and they file their taxes separately, their AGI is going to be half of what the married couple's total income is. Now, part of the SAVE litigation made it that if the borrower filed their taxes separately from their spouse, they could not include their spouse in the family size. But due to the SAVE injunction, they are now, because that change was part of the SAVE regulatory package, and because the most recent injunction in February blocked that entire regulatory package, borrowers who file their taxes as married filing separately will once again be able to include their spouse in the family size, which is actually a positive thing. And that applies to all the plans. Now, all the plans under regulation technically forgive any remaining balance that's left after a certain period on the plans. Now, for new IBR and pay as you earn, that's 20 years. For old IBR and ICR, that's 25 years. The issue we're having is that the SAVE litigation is calling the legality of the forgiveness specifically under ICR and pay into question. And again, we'll talk more about that later, but be assured that the forgiveness under IBR and new IBR is specifically written into federal law and is not at risk. For new IBR, old IBR, and pay as you earn, they do subsidize any interest that's not covered by the borrower's billed payment for their subsidized loans only, and only for the first 3 years that they're under the plan. Now, the SAVE litigation is also calling the subsidized interest for pay as you earn into question. So as of February, that interest is not being subsidized specifically for pay as you earn. All the plans, if your income is low enough, you could end up with a $0 payment, and $0 payments do count towards the number of payments needed for forgiveness under the IDR plans. And for borrowers that are on an IDR plan and pursuing public service loan forgiveness, a $0 payment also counts towards PSLF. Now, it's important to remember there's a difference between being billed a $0 payment and not being due a payment because your loans are in forbearance or deferment. Your loans are in forbearance or deferment, with few exceptions, it doesn't count towards forgiveness. But if you're being billed for $0 because your income is low and you're on an income-driven plan, then those payments do count towards forgiveness. Now, all of these plans base the payment on a concept called discretionary income. Now, discretionary income means something very different than what most consumers think of when we use the term discretionary income. When most of us use the term discretionary income, we're talking about our fund money, the money that's left over after we, pay our housing costs and our electricity bill and our cell phone bill, and maybe even our groceries and retirement. Discretionary income under the income-driven plans is defined as the borrower's adjusted gross income minus a certain percentage of the poverty level based on their family size. Now, for old IBR, new IBR, and pay-as-you-earn, they're using 150% of the poverty level. ICR only uses 100% of the poverty level. Now, you'll notice I'm not talking about SAVE. SAVE was a lot more generous here. They used 225% of the poverty level, which is why most borrowers, that was by far the lowest plan. But SAVE is dead. Whether the courts kill it or Congress kill it, that's the only sort of outstanding question there. So for that reason, I'm not sort of bothering talking about how SAVE works, because SAVE is 1,000% dead. And there is absolutely, the current administration and Congress, for that matter, have issued a DNR on that. So that's why I'm not talking about SAVE. So going back to discretionary income, to show you how that works, if we assume that a borrower has an adjusted gross income of $62,000, they have a family size of 4 living in the state of Maryland. So the poverty level, which I actually think is the last year's poverty level that I'm using in this example, for a family of 4 living in Maryland is $26,200. 150% of that is $39,300. So you subtract that from their AGI, that gives us $22,700. And that's the jumping off point they're using for the calculation for new IBR, old IBR, and pay-as-you-earn. So you divide that by 12, that gives us $1,892. And if you're looking at pay-as-you-earn or new IBR, they're using 10% of that discretionary income to determine the payment amount. And so that would be $189. Old IBR, they're using 15%, which would give us a payment of $283. Now, remember, if the borrower is married and they file their taxes jointly, they're using both incomes. So, unless the other spouse has loans of their own, in which case they're also looking at both loan balances as well as both incomes, or that spouse doesn't have much of an income at all, you would expect the payment to be a lot higher. Few other items that are the same for most of the income-driven plans. With the exception of income contingent, you are required to have what's called a partial financial hardship to enter into new IBR, old IBR, or pay-as-you-earn. Now, a partial financial hardship means that your calculated payment under those plans is less than what your payment would be under a 10-year standard repayment plan. So, for example, if we look at our same borrower, they have an AGI of 62,000. Let's assume they owe 60 grand in loans. If we assume their interest rate's around 6%, their payment under a 10-year standard plan would be about $720. Now, $720 is a lot more than what we calculated their payment to be in the prior slide. So $720 is a lot more than $189, which would be their payment on new IBR and pay. and it's a lot higher than 283, which is their payment on old IBR. So in all three of these cases, assuming that their loans weren't too old to be qualifying for new IBR pay as you earn, this borrower would be eligible for all three of those plans. Now, the other side of that coin is that new IBR and old IBR and pay as you earn, because they require a PFH to enter into the plan in the first place, they also cap the payment. So if the borrower's income goes up by quite a bit over time, and they get to the point where their calculated payment is the same or higher than what they would have paid under a 10-year plan, they don't get kicked out of the plan. Their payment just caps at their 10-year standard amount. Under ICR, there's no PFH requirement to get in, but that also means that there's no cap at the 10-year standard plan. However, ICR has its own cap, which I'll talk about in a little bit. Now, when the SAVE plan existed, there was no cap and there was no PFH. So anybody could get in, but your payment there was no limit to how high your payment could get. If someone enters into one of these plans that requires a PFH and they hit the 10-year standard amount and they end up actively leaving the plan to go on a different plan and then want to go back into old IBR, new IBR, and pay as you earn, they're not going to be let back in. So you have to have a PFH to get in the first place, but you can stay as long as you like. But if you leave and then your income is higher than what you would get under the 10-year standard, you can't get back in. All right. So, well, actually, I think that was a good time to check in with Addison because I've seen a couple questions come in. Is there anything that I've covered so far that you've got questions on that you think might be good with the group for the group?
No, not right now. I think they're being very nice and waiting and following your instructions as instructed, which I appreciate, but I hope the floodgates will open soon with questions.
Yes, I do too. And I know I have a lot of friends here on this call. I do challenge you to challenge Addison. He loves it. Sorry, not sorry. Okay, let's talk a little bit more about Parent Plus loans. As I mentioned, Parent Plus loans in and of themselves are not eligible for any income-driven plans. However, if they consolidate their loans, they become eligible for ICR, but ICR only. And ICR, for most borrowers, tends to be the most expensive plan. The only exception to that statement is for borrowers whose income is high compared to what they owe. In that scenario, ICR can actually be the lowest of the income-driven plans, which can be useful to someone who's very close to forgiveness, say under a public service loan forgiveness. So they need to be on an ICR, but they don't qualify for old IBR, new IBR, pay as you earn because they don't have a PFH. In that case, ICR actually can be really useful to those borrowers. Now, there is a loophole called double consolidation. Now, the deadline for double consolidation was July 1st of this year, meaning you had to have the double consolidation done by July 1st. Now, those of you who've been around a while will note that anytime in the past that we've had deadlines related to consolidation, the deadlines have been for applications submitted on or before the deadline. But this one specifically didn't say that. It specifically said you had to have completed the double consolidation by July 1st in order to get the benefits of the double consolidation. And the benefits are that you can qualify, assuming you meet the other eligibility criteria. A double consolidation Parent Plus loan has access to old IBR, new IBR, and pay as you earn, as well as ICR. Now, that deadline was part of the SAVE regulatory package. So because of that injunction in February, that deadline currently doesn't exist. Now, it could come back depending on how the stuff with the court shakes out, or it might not come back. So for borrowers that are saying now, is it too late here at the end of or middle of April to start the double consolidation process? I say no, for a couple of reasons. First of all, it's not impossible that someone could finish double consolidation by July 1st. It's getting awfully tight. and it's certainly not a certainty that they'd finish by July 1st, but it's not impossible. But let's say they don't finish and the deadline comes back. They haven't really harmed themselves because they're still eligible for ICR and they're still eligible for the other non-income driven plans that they were eligible for before. So I say no harm, no foul as far as starting a double consolidation process right now. If for those of you wondering what double consolidation is, it can be really confusing to explain. So we actually have it all written out step by step under the consolidation page of our website. But really quickly, it means consolidating each of the Parent Plus loans twice. So for example, let's say a borrower had Parent Plus loans A, B, C, and D. The first thing they would do is consolidate loans A and B together to create consolidation 1. And they would consolidate loans C and D together to create consolidation 2. And then the last step is they consolidate loans, consolidations 1 and 2 together to create consolidation 3. So that's essentially how the double consolidation works. It really, if you're contemplating that or advising someone to contemplate it, I strongly advise you to go read up on it on our website, because there's a reason we call it a loophole. It's not illegal, but if you don't do it in a certain way, for example, using paper applications and choosing different servicers for every step, you can screw it up permanently where you'd end up being barred from double consolidation. So make sure you do your homework on that. All right, so just really quickly to see how these different plans shake out. If someone has a balance of $95,000 and an adjusted gross income of 30 grand and a family size of 2, and we assume an income growth of about 2.5% per year, under a standard consolidation plan, the borrower would have a payment of $570 a month, and they'd pay back more than twice what they borrowed if they took the full 30 years to pay it off. If they got on old IBR, their payment would start out as $52 a month, so 10% of what their payment would be under a standard plan. But more importantly, they'd only pay back a total of $23,000 before they would get forgiveness under old IBR. New IBR is even less than that. Their payment would start out as $35 a month. They'd get forgiveness after 20 years. They'd only pay back a total of 11.5 grand. Pay as you earn, remember, is the fraternal twin of new IBR. So the numbers work out to be the same. But remember, the forgiveness component of pay as you earn is currently at risk. Now, the reason I put revised pay as you earn in here is because, I mentioned that SAVE is dead. But back in January, before the inauguration, the Department of Education issued a Federal Register where it appeared like they were revising repay to meet the criteria of all these court injunctions. So essentially a replacement for SAVE. Now, I have no idea if they plan on continuing with doing that, but based on what was written in that Federal Register, it looks like the monthly calculation would pretty much be what we have for pay as you earn. So that's why but would have a 25-year forgiveness component. Again, the forgiveness component is at risk there. So that's why I threw those numbers in to this chart. If that payment plan were to go through, and if the forgiveness component of those plans ended up remaining, that's what that would look like. So the borrower would have the same monthly payment amount. They'd pay back a little more than what they would pay back in total under new IBR or pay as you earn. And for ICR, this borrower would have a payment of $213 a month, and they would pay back a total of 90 grand before getting forgiveness. Now, unlike public service loan forgiveness, any borrower who gets forgiveness under the income-driven plans after December 31st of 2025, assuming Congress, and I really hope they do, and I think there's a chance they will, Congress put a moratorium on the taxability of forgiveness under the income-driven plans, but that ends at the end of this year. So if Congress doesn't make that permanent or extend it, anybody who gets forgiveness under these IDR plans after December 31st, they're going to get a tax liability. Now, they don't get it. Let's say they get $100,000 forgiven. They don't get a tax bill for $100,000. That's just included it as taxable income. So a lot of borrowers that are pursuing forgiveness under these income-driven plans, they're also creating a savings account to sort of save up for this potential tax liability in case Congress does not extend the moratorium or make it permanent. Incidentally, that same tax moratorium also doesn't tax forgiveness for total and permanent disability discharge and death discharge. So if Congress doesn't extend it, those borrowers will also get a tax bill. So I'm encouraging everybody within the sound of my voice to write to their member of Congress or their senator and encourage them strongly and explain the implications if they don't extend this tax moratorium or make it permanent. My fear is that with everything else going on, this is actually flying under the radar a bit. And the time for them to do it will be through budget reconciliation. So all of you, if you have an extra 5 minutes, please, please, please reach out to your congressional representatives and explain the implications of this, especially for, if you think about somebody, if you look at this example, somebody who owes 95,000 in loans and has an AGI of 30 grand and never gets more than a 2.5% raise over time. And, these borrowers exist. This tax liability can be incredibly crippling to them. And that certainly was not the intent of when Congress created these income-driven plans in the first place. So you guys are in a great position as professionals in the industry to educate your members of Congress about that. So stepping off the soapbox on that one now. Okay, so that's the primer on the income-driven plans. Before I start going over the SAVE litigation and other things, I want to check in again for questions about how those plans work. Oh, really quick, while Addison's deciding whether to ask me anything. Pay as you earn and ICR went away as part of the SAVE litigation. They sunsetted. So anybody who wasn't already on the plan could not get into the plan. But then when the SAVE injunction happened and people couldn't get into SAVE anymore, the Department of Education brought back pay as you earn and ICR as long as you were in it by 2027. Anybody could get in those who were eligible could get in those plans as long as they did it by 2027. Also, as sort of a postscript to that, they did not sunset ICR for Consolidated Parent Plus borrowers. So Consolidated Parent Plus borrowers will always be able to get into ICR, at least based on everything that's going on. And I don't expect that to change. Now, with the SAVE litigation and what's happened with the injunctions, I'm not sure if they're going to extend the eligibility to get into pay as you earn an ICR further, but they just announced a negotiated rulemaking around PSLF, pay as you earn, and ICR. So I think we're going to get an answer to that as part of that negotiated rulemaking session, which is going to start this summer. So, Addison, anything about what we've covered so far?
No, not as of yet. I know these are all the smartest people, so I've heard good things.
They are very smart people. They could probably give most of this presentation. They're here for the tea. And so let's start talking about the tea. All right, SAVE litigation. So as you all know, the Biden administration attempted to introduce this very generous plan that was helpful to a lot of borrowers. And 13 attorneys general said, nope, you don't have the authority to do that. It's an overreach. And they filed a lawsuit. And we've had a couple of injunctions around that lawsuit. The first one essentially stopped people from getting on SAVE any further, and anybody who was already on SAVE was put in forbearance. Now, the SAVE forbearance does not count towards any type of forgiveness. It's supposed to be a 0% interest rate. I know there's at least one servicer that's still charging interest, but my understanding is that they're going to back that interest off down the road, probably when the SAVE forbearance ends. Other servicers are just applying the 0%, much like we saw for the COVID forbearance. For borrowers that are pursuing PSLF, they can do what's called buyback for the SAVE forbearance months. And what buyback is you have to have hit 120 certified months of employment. And then you reach out to the Department of Ed and say, listen, I'm at 120 payments, but these SAVE forbearance months don't count, or whatever other months they are don't count. Tell me how much I would have paid if I hadn't been on this forbearance. And the Department of Ed gives them a number. And if they choose to pay it, they pay it. And then those months count and they can get their PSLF forgiveness. There is no buyback for income-driven plans right now. Now, we had another injunction in February, on February 18th, and that's the injunction that blocked the entire regulatory package that SAVE was under. And because of that, they had to pause new applications and recertifications for all the income-driven plans. And the reason for that is because part of that SAVE regulatory package, as I mentioned earlier, it changed how the spouse was counted in the family size for borrowers who are married and they file their taxes separately. So because of that, they had to pull the application down so they could change the language on the application. And they had to tell the servicers to stop processing and including annual recertifications, to give them time to give them guidance on the new family size definition and give the servicers time to code everything differently to reflect the new family size definition, and of course, educate their staff. Now, they have since brought up a new form and they have started processing again. Now, the guidance, the language that's out there says that they're only processing, they're processing for everybody except borrowers that are married and file separately. But a little bird has told me that they actually have started processing those now as well. Or if they haven't, they are going to start in the next couple of days. But that's unofficial, let's call it gossip. Now, because borrowers could not recertify their loans, they ended up extending the annual recertification deadline for a lot of borrowers. And I'm going to cover the details of that in a minute. But essentially, anybody that was due to recertify their income-driven plan on or after February 21st was extended by a year. And then some people that sort of got caught in the crossfire, they were due to recertify during the couple of weeks of the injunction confusion. You'll see that they may also be getting an extension. Now, a borrower that needs to access an income-driven plan but can't because of this pause, and now that the pause is lifted, there's a backlog they have to deal with. If they are at risk of delinquency, they can call and ask for forbearance during this period so they don't go into default or they don't get the 90-day past due or more ding on their credit. As I mentioned, the forgiveness component for ICR and pay as you earn is specifically at risk under the SAVE litigation. I actually don't know how this cropped up because this was not something that those attorney generals were questioning. But the sticky, and remember, ICR has been around since 1994, and no one's ever questioned the forgiveness component. Borrowers have had forgiveness under ICR. I think the first year they were eligible or potentially eligible was 2019. But now the courts are saying that Congress, so if you look at the federal law language around ICR, it says, the borrower makes a payment based on their income, for no more than 25 years, but it doesn't specifically say what's supposed to happen after that 25 years. And so everybody assumed the balance gets forgiven and no one ever questioned that that was the assumption. But now the courts are saying, well, because Congress didn't use the actual word forgiveness, we don't think the Department of Ed has the authority to offer forgiveness there. And that's a real gut punch, again, for, people that have been on ICR for 24 years and 11 months, for example, and maybe they're not eligible to get on IDR because they have Parent Plus loans that aren't double consolidated, or maybe they don't have a partial financial hardship. Now, the reason pay as you earn is also affected is because pay as you earn was written under the ICR umbrella. So that's why the forgiveness component for pay as you earn is also at risk. Now, if they do this new revised pay as you earn to replace SAVE, that forgiveness is also potentially at risk because SAVE was also written under the ICR umbrella. So if the courts do end up deciding for sure that the forgiveness component doesn't exist for ICR and pay, I frankly have no idea what's going to happen to those borrowers. I don't know if they're going to grandfather in borrowers already on those plans for forgiveness. It's very possible that they will. Courts historically have not been inclined to remove benefits already granted to borrowers. They definitely, for that reason, they definitely won't be removing forgiveness from anybody who already received it under pay as you earn or ICR. We just don't, we don't know how that is going to play out. I mean, one way to solve this is for Congress to actually put the word forgiveness under that legislation, and it's not impossible they would do that. It's not a great time for that ask, but this is also something I'm encouraging people to write to their members of Congress and understanding the implications of it. Would it be that they get a balloon payment, which would be unaffordable for most borrowers, or would these borrowers just be stuck paying for the rest of their lives, or until the balance is gone, whichever is sooner? Now, borrowers on this SAVE forbearance, they can choose to either ride out this forbearance because they're getting a 0% interest, or they can choose to switch plans now. And we get this question here at TISLA all day, every day. What should I do? And there's really no clear answer for most borrowers. If you're someone who qualifies for IBR and you've made close to or more than 300 payments already, or the 240 needed for a new IBR, you should switch and accrue the rest of the payments you need to get IBR forgiveness. For borrowers pursuing PSLF, again, it depends. And the unknown here is, I mentioned that PSLF borrowers can use that buyback concept. Problem is, we don't know what calculation they're going to use for buyback for the SAVE forbearance period. If they're going to use SAVE, then the SAVE calculation, then riding out the SAVE forbearance as long as possible and planning on using buyback is probably the cheapest option. But we don't know if they're going to be able to use the SAVE calculation if SAVE is deemed, which we know it will be, unlawful. So in that case, are they going to use the 10-year standard amount, in which case you should switch as quickly as possible? Or are they going to use the next lowest income-driven plan amount, in which case it's sort of a wash whether you switch now or ride it out? So there's just a lot of factors as to whether people should ride out that SAVE forbearance or switch plans now. Because of the February injunction, they briefly paused online consolidation applications, but that came back really quickly. They really basically had to, the income-driven plan application was tethered to the online consolidation application. And so basically once they untethered that, they brought the online applications back up. PSLF is not affected by any of this injunction. One thing I want to mention though, so last Friday, there was a declaration submitted to the court from the Department of Ed, specifically from James Bergeron, soon to be Chief Operating COO of FSA. And in that declaration for the SAVE litigation, they put in language saying that effective May 10th, that borrowers that were married and filing separately could no longer exclude spousal income, and that both spouses' income would be used regardless of tax filing status starting May 10th. And as you can imagine, all heck broke loose. Borrowers were panicking over this. So I took a look at it, and first of all, they can't do that because the exclusion of spousal income under IBR and ICR is very specifically stated in the law. And the Department of Ed can't do anything contrary to federal law. They can't write a regulation that's contrary to federal law. So I thought this was a mistake just based on that. But then I went and looked at the new version of the income-driven plan application that was issued a couple weeks ago after the February 18th injunction. And I also looked at the draft IDR application that was part of that declaration. And both of those forms specifically included the correct language, which said that if you're married and filed separately, you don't include spousal income. So I really thought it was a mistake, and turns out it was a mistake. So yesterday, I think it was yesterday, they actually issued a correction to that declaration and confirmed that what they meant to say was that because of the save litigation, borrowers that are married and filing separately can now include the spouse and family size, whereas they had to exclude the spouse from the family size before. So some of you might be going, well, Betsy, if this was a mistake, why did you just spend, a minute and a half of our lives explaining it? And that's because a lot of people, there was a bunch of news articles written about this, and they did not say that it was potentially a mistake. And the borrowers aren't necessarily going to see that it was a mistake now that it's been corrected. So I am making sure that my favorite MEFA audience is educated. So if you ever hear anybody say you can't count spousal income anymore, you can go, no, that was an error and the error has been fixed. All right. So I mentioned that recertifications of IDR plans for some borrowers were affected by this February 18th injunction. So here's what they ended up doing. So just as a reminder, if you fail to recertify your income when required to under the income-driven plans, they don't kick you out of the plan. They did for SAVE, but SAVE is irrelevant now. So you stay on your income-driven plan, but they kick your payment up to what you would have paid under a 10-year standard amount. So for borrowers, there's a difference between your anniversary date and your recertification due date. Your anniversary date is 12 months from when you initially got on your income-driven plan, and it's sort of the same anniversary date every year. But you're due to submit your income-driven plan recertification documents at least 45 to 60 days prior to your anniversary date, because you have to give the servicer time to process it. So your anniversary date is when your payment's going to change, assuming your income has changed. Or if you fail to recertify on time, when your payment will kick up to the 10-year standard amount. Your recertification due date is when your paperwork is due to ensure that you don't get, kicked up to the 10-year standard amount. So for borrowers whose anniversary date was before on or before March 17th, and they had a recertification that was due on or before February 20th, if they had already submitted their recertification on time and it was processed and they have a new payment amount, nothing's going to change for them. Their recertification due date's not going to change. Their payment's not going to change. Whatever their new payment is their payment. If they submit it on time, so by February 20th, assuming that was their restart due date, and it wasn't processed, they're basically going to throw away your recertification. And so you'll stay on your old payment amount, and they're extending your recertification due date for a year. If you did not submit on time, you do have to recertify your income, and you will have, if you haven't already, been kicked up to the 10-year standard plan amount. Now, if your IDR anniversary was on or after February 18th, and your recert was due on or after February 21st, they've extended you by a year. So nobody is going to be due until at least February 1st of 2026. Now, if in the meantime they did kick your payment up, they will revert your payment back to the old payment amount. I feel like I'm forgetting something about this. Oh, whatever it is. I do expect it to take a while for the servicers to, for anybody that was kicked into the 10-year standard that shouldn't have been because they recertified on time and their anniversary and restart dates were on or after those dates you see in front of you. They will get reverted back, but I do expect that to take some time, maybe even a couple months. I hope it's not that long. Something similar happened the beginning of last year, only this wasn't a save litigation issue. It was a servicer made a mistake issue. And there are some borrowers that were never reverted back. I don't think that will be the case this time. I'm hoping it isn't. But if you were affected by this, it's something you're definitely going to want to keep an eye on. All right. So that's what I had around the IDR plans and the save litigation. I did want to prognosticate about the effects of the RIF, the upcoming NEGREG, and the budget reconciliation. But before I do, I'm going to check in with Addison again.
No, we are good.
All right. Okay. So, as all of you are very aware, there was a large reduction in force with the Department of Ed. What was it, a month or so ago now? Um, and I'm not sure if your shops are seeing the effects of this. My shop is seeing the effect of this because a significant number of the employee, I was able to get a quick look at the list of the people that were laid off. And of course, a lot of the people that I work with on a fairly frequent basis, I was aware from them. But they got rid of both entire teams that do oversight of the loan servicers. They get rid of 80% of the people that do program reviews and audits for schools. They got rid of the entire foreign schools team, and they have no place for the foreign schools teams to go, which means any foreign school that is trying to get into Title IV in the first place, they're currently at a pause till who knows when. They got rid of all of the ombudsman team except one person. So essentially, they got rid of all the people that try to prevent fraud and abuse. Um, and they got rid of almost all the people that resolve errors and dispute for borrowers. So I find that ironic because the whole purpose of this was to supposedly eliminate fraud and abuse, when essentially, in my opinion, they've sort of opened the door to fraud and abuse. Um, we have seen, thinking back to the Corinthian debacle, the vast majority of colleges and universities do the right thing, but anytime there's a lot of money involved, there's always going to be bad actors. So take that with the fact that they're also looking to get rid of gainful employment rules, as well as significantly water down borrower defense to repayment relief for borrowers. And I think we're setting the stage for some real issues that are going to affect borrowers significantly in the future. They took away the helpers and the protectors. And from a school perspective, with 80% of the school teams gone, I suspect that you're also going to have difficulty if you have issues that you need resolved. Um, Getting those issues addressed, I think is going to, I mean, we are the day after the RIF, the FAFSA went down, and they had to bring like 50 of the IT people back that they had laid off the day before. They had to bring them back to their jobs. I think in the end, we might see quite a few of those positions come back. But unless and until that happens, that declaration error that I mentioned, that's absolutely because of the RIF. We have less people having to do the same amount of work, and mistakes are going to happen. Now, we did see 21 attorneys general file lawsuits saying the RIF was unlawful. I haven't seen any progress of that case recently, but that's something else that we're watching. The other thing we saw in the last month or so was an executive order around public service loan forgiveness. And what the executive order said was that anybody who worked for an employer that would normally be an eligible employer under PSLF, so a government employer that's, city, town, state, federal, military, or any 501c3 nonprofit or other nonprofits that aren't 501c3s but that meet certain other criteria, if that organization was deemed to be doing quote unquote illegal activities. And the things they listed as so-called illegal activities included working with illegal immigrants, terrorism, DEI. Of course, DEI is the theme of a lot of things lately. That period of employment would not count towards PSLF. Now, they have since announced a negotiated rulemaking, and part of that negotiated rulemaking is going to be supposedly to implement this executive order. So to be clear, this isn't immediate. The executive order specifically told them to do NEGREG to achieve the goal of that executive order. NEGREG takes usually at least a year. NEGREG can never be retroactive. So anybody who works for an organization and they're afraid that they might fall under that umbrella, don't worry about past periods of employment. In my opinion, I don't necessarily think you have to worry about future periods of employment either, because at least, at least for government employers and 501c3s, that definition is very clear under PSLF federal law. And I don't personally read any wiggle room around that. So if you work for a 501c3 or you work for a government employer, even if that entity did do one of these things, they, in my opinion, they can't exclude that period from PSLF. Now, what they might be able to do is make those entities no longer 501c3s. I'm not as fluent in IRS law as I am in student loan law, but I did take a quick glance at it, and I didn't see a lot of wiggle room under IRS law for 501c3s either. So it's going to be really interesting to see how this plays out for NAGREG. I do know that if they do try to pass a regulation that is contrary to federal law, there will be a lot of lawsuits, and I think that those lawsuits will be lost by the Department of Education. But again, regulations can't be retroactive. So if this turns out to have some teeth that might hold water, we'll know well ahead of time. Borrowers should know well ahead of time before that regulation goes into effect. We also saw an executive order to move the student loan portfolio to the Small Business Administration. I haven't heard anything about that since. It's questionable whether they even have the legal ability to do that. Just today, David Bergeron, who was the prior acting assistant secretary under the Obama administration, and David Bergeron, a lot of you probably recognize the name. He was at the Department of Education forever. But he just wrote a great article for the Center of American Progress about this, about the potential legality of it, and the intelligence of even if it was legal, whether they should be doing it. If you're interested in this topic, I suggest you head over to CAP and take a look at his article. But I haven't heard any chatter on that. I wonder if that was a little bit of political theater. And they may not actually end up doing it, but we'll see. But borrowers' fears for that is that the terms and conditions of the loans will change, PSLF won't exist anymore, and so on. And we all know that's not true. If the loans did move over to SBA, the only thing that would change is who oversees the program. The servicers and the vendors would remain the same. The terms and conditions of the loans would remain the same. I'd like to think the remaining ed employees would go with it, but I actually don't think it will happen anyway. All right, so as I mentioned a few times, they did announce a negotiated rulemaking session specifically for PSLF, pay-as-you-earn, and ICR. PSLF, I think what they're gunning for is to go through the motions of trying to implement that nonsense, in my opinion, nonsense executive order. Here's something else, and this is, again, 100% speculation on my part. The last time they did an update on the studentaid.gov website about the SAVE litigation, specifically around that February 18th injunction, it's kind of buried in there. They also mentioned that in the future, borrowers might be able to do buyback for PSLF before they hit the 120. So, and that's all it says. So here's my speculation on that. Either they're going to try to get rid of buyback altogether as part of this NAGREG, and you will have to have, if you're going to buy back months, you have to have done it by a certain date in the future. Or they're going to change the reg on buyback and make it that you don't have to be at 120 at any point to do buyback. So that's what they're going to address for PSLF. For pay-as-you-earn and ICR, I'm not sure. I wonder if they're going to be sunsetting those plans additionally, or if they're going to be just trying to alter those plans to make it fulfill what cropped up during the SAVE injunction. And I wonder if they're going to address the fact that the forgiveness component of those plans, if they're going to try to solve that issue as part of this negotiated rulemaking session. Now, the public hearings for that are April 29th and May 1st. The May 1st, if you want to testify, anybody can testify. If you want to testify, you can sign up. You can do it virtually for the May 1st session. If you want to do it in person, you sign up for the April 29th session. And you sign up for that, I believe, through regulations.gov, but it's in the Federal Register. They're also looking for suggestions on things other than PSLF, pay-as-you-earn, and ICR that would, quote unquote, streamline current federal student loan financial assistance program regulations. Now, one of the other targets of this administration is to get rid of as many regulations as possible. So I think that's what this is about. So, I think as long as it's student loan specific related, not necessarily loan origination, but loan repayment or forgiveness or discharge related, I think anything could crop up as part of this neg reg. And rumor on the street is they want to start the actual meetings around June. So I think the next thing we'll see happen with this neg reg is they'll do a call for nominations for negotiators. And of course, they always have schools at the table. So if you want to be a negotiator, keep an eye out for that. I am going to try to get nominated. I might regret it, but I am going to try to get nominated under borrower advocacy umbrella, assuming they have a place at the table for that. All right. So I'm very closely watching budget reconciliation because I think any real significant changes we see to the student loan or financial aid programs is going to be through budget reconciliation. Some of the proposals I've seen that I think have some serious legs are ones that would, and if you attended the MASFA conference, this is going to look familiar to you. Schools being allowed finally to limit loan amounts in certain circumstances. It wouldn't be, you wouldn't be able to do it in a discriminatory way. But for example, if you have a program that the ROI is very low on, you might be able to limit borrowing amounts for that particular program. I do think that's coming. It's something everybody agrees with and has for years. They are looking to streamline the repayment plans for future loans to only two. They would be really three. They'd be the 10-year standard, the consolidation standard, and one income-driven plan. That income-driven plan doesn't have a forgiveness component per se, except that they would forgive any balance that if the borrower was on that plan and they got to the point where they paid back the equivalent in principal of interest as what they would have paid under a 10-year standard, then they forgive the rest of that. So, but what that means is for borrowers with high debt and very low income, under this plan, they literally would have their student loan debt hanging over their heads for the rest of their lives, unless they qualified for some other discharge down the road, like PSLF or total and permanent disability. So that's very troubling. Now, the nice things about the plan is that it appears to forgive interest not covered by the borrower's calculated payments. We wouldn't be in a situation that we sometimes see with the other IDR plans where the borrower pays every month and their payment just goes up. It also, if their payment was very low compared to how much interest was accruing, some of that payment would go towards principal. So the borrower would be able to see some progress being made. The monthly payment, it sounds like it would be the equivalent of what borrowers currently on pay-as-you-earn or new IBR would get. So 10% of discretionary income, and discretionary income appears to be defined the same way. So AGI, although under this proposal, they'd have to include spousal income regarding of tax filing status, but it would only be for this new plan. They are proposing getting rid of every single one of the higher education related tax credits, American Opportunity Credit. They're talking about taxing scholarships. I actually don't think that the taxing scholarships thing will have any legs. And the tax credits, I suspect they won't get rid of them all. Well, they might get rid of them all, but create one new one that will supposedly replace them all. But the outcome will end up being a lower tax credit. That's my prediction of what they'll do there. Of course, they're talking about eliminating grad and parent plus loans. It wouldn't be a cliff. It would be more of a downhill. So anybody already enrolled in school would probably be able to still get those loans until they finish that program, assuming that they didn't take more than the average amount of time it took to complete that program. Stafford loans would have an annual limit that would be related to the median cost of that program. And there would be an aggregate loan limit for everybody, including graduate students, of either 150 or 100,000 or a total aggregate of 200,000, depending on the degree program that they were pursuing. So my fear with this proposal, and I think there's a real possibility that this could go forward, My fear here is that will significantly increase our non-completers. Because if you have someone that already has significant student loan debt because they've maxed out their federal loans, they might very well not be able to qualify for a private loan. And they might not have a cosigner in there willing to do it or able to do it for credit reasons as well. And therefore, that might mean they have to drop out of school. And we know what happens with non-completers. They have a very high risk of default. So I understand what they're trying to do here. They're trying to ameliorate the student debt issue. They're also trying to sort of force colleges to adjust tuition prices. They're doing that in other places in these proposals, not just here. But I think the consequences of that is going to be a huge increase in non-completers and therefore a huge increase in defaults. So it's something I'm watching really closely. And with that, I'm like 2 minutes over time, but that's what I had for you today. If you want more information about any of these, you should go to our website, which, by the way, we're about to do a big refresh on in the next couple of weeks. So watch for that. And of course, studentaid.gov. And I've got a couple of minutes to hang out if there are other questions. Addison, anything?
This might be the record for the quietest group.
You guys were too nice to him. All right. Well, once again, I want to really wholeheartedly thank MEFA for sponsoring this webinar. If if you think this webinar would be useful to your alumni or your students, definitely reach out to us. Same for public service loan forgiveness. We're happy to work with you to do programs like that. And of course, we have our public service loan forgiveness peace of mind program that we have several clients with schools and cities and so on that find it very useful to help their employees who are pursuing PSLF and also help the institution use PSLF as the free benefit for their employees that it is. So if you have any interest in those, don't hesitate to reach out either. Julie or Sean, did you want to add any closing words?
Betsy, I just want to thank you for joining us today. It was really informative. And there was a question that came through a different channel. And if there is a date when the save borrower forbearance will end, your comment said fall, but I didn't know if there was an exact date when that would end.
There is. I think is it August, Addison?
I believe the Department of Education has said they expect the forbearance to end in September with repayment beginning no earlier than December. But of course, that's all contingent on what plays out in the courts.
Yep, that rings true to me.
Thank you. It looks like there's a couple other questions coming through now.
Did you have any thoughts, Betsy, on eliminating Grad Plus loans?
Yeah, so someone said eliminating Grad Plus would also provide opportunity for graduate level education for many. You know, who this is going to affect is the lower and middle class. So I have significant, their access to education and their choice for education. So I have significant concerns around that for sure. Now, remember, graduate borrowers, they'd still be able to borrow, I think it's up to $20,000 a year. So I think the higher cost programs are the ones that would suffer for enrollment. But again, that eliminates choice for these borrowers. Yeah, I mean, when we have significant updates, I'll see if there's a call out there to do additional webinars. And you guys can always reach out to us if you have an audience that you think would benefit from a webinar like this as well.
Thank you, Betsy.
I'd just also like to add that we do provide major updates on the TISLA website when there's big news breaking. We try and keep our page fairly up to date on that. So TISL website is also a good resource for people to check out.
And especially in the next couple of weeks when you get to see our refresh. And if for no other reason, if you need something to give you some mental calmness, we have added the TISLA pets to our staffing page. So, and if you want to take a look at our, the cutest of our staff members, I recommend you go there.
I love that.
And Betsy, I'm supposed to remind you to plug Peace of Mind.
Oh, I just did. But thank you. Again, remember, if you're, I don't understand why all the colleges and universities don't do more to help their employees navigate public service loan forgiveness. Because again, it's a free benefit to those employees that they can offer. I think they should all be putting it in their job listings and putting education for it through the rest of the employee benefits. And that's one of the things we do with the PSLF Peace of Mind program for our clients that are a part of it. It's really reasonably priced. And again, it helps PSLF eligible employers utilize PSLF as the free benefit that it is. All right, I guess I will give everybody back the rest of their afternoon. Thank you. Nice to maybe not see everybody, but know you're all there. And I'm sure I'll be talking to you soon.
Thank you, Betsy.
Thank you.